rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here today in our case 1 CV 160096 LEXON versus Valley Springs. Each side will have 20 minutes to present their argument. Plaintiff, you may reserve as much time as you want for rebuttal, but you're responsible for keeping track of your time. We have a clock at the podium for that purpose. We are recording the argument today. In a couple of days, it should be on YouTube if you want to watch how you did. Because we're recording the argument, we ask that you identify your client and yourself when you begin so that we can keep everything straight. We've read the record and the briefs, and we've conferenced the case, so we're familiar with it. So when you begin your argument, just launch right into what you would like for us to know. Counsel, you may begin.
Morning. May it please the court, I'm Colleen Mehring, counsel for the appellants, a group of developers and investors, including Mr. James Leo Crowley, who's here in the courtroom. Your Honors, as you know, we brought 3 issues of law on this appeal, but where I'd like to start is actually with the prejudice that underlies all 3 of those issues. Plaintiff LEXON brought a case against my clients in early 2013 that alleged that my clients had violated written contracts, that those contracts were exclusively written, and that they had disclosed all portions of those contracts. They then swore repeatedly in discovery that no schedule of rates, which of course later became the focus of this case, that no schedule of rates existed. That is the case that my clients prepared to meet. That is the case that they took depositions to meet. That is the case that they formulated a trial strategy to address. That's the case that they selected a defense theory to move forward on. So fast forward to June 2015, and now all of a sudden, contrary to all these previous representations, plaintiff alleges there is a schedule of rates. Puts that forth with a sham affidavit that gets stricken, but the schedule of rates survives the judge's pretrial ruling, and my clients are left with the option of not just taking a little extra discovery, but literally redoing 2 years of trial preparation to attempt to meet the new case, which of course could change again. And in fact, it did change again. As you know, my clients went forward and said, we just need to get to trial. We have to move forward. We'll impeach LEXON on their earlier representations and now the sudden appearance of the schedule of rates. So we arrive at trial, and now not only is it no longer just written contracts that have been fully disclosed, but also it becomes a trial of LEXON's business and the industry standard. And so instead of the case that my clients are prepared to meet, we have a trial on a case that is not LEXON's complaint. That is my client's position and underlies each of these issues. So I want to move to that first issue. We argue judgment as a matter of law should have been granted for my clients. LEXON's complaint required, and their admissions and allegations required, the schedule of rates be incorporated by reference into the contract. That's not possible to have happened in this case. And this is an issue that this court reviews de novo. It's a question of law, or as one case puts it, at most a mixed question of law and fact, which this court reviews de novo. This document, most importantly, was not readily available. Not only was it not readily available for the 2 years between the filing of the complaint and the beginning of the trial, well, more than 2 years, It wasn't in the underwriting file. It wasn't in the collections file. No one, until the eve of Lexon losing summary judgment, no one knew that it existed. People swore that it didn't exist. It was this unknown thing. So to take that document and say, and to find that it was possible for it to have been readily available, we say is a matter for the court, and the court should have decided it couldn't have been incorporated by reference. And again, on Lexon's complaint, they couldn't have won. Again, this is Lexon's complaint. This is not just Lexon's complaint, it's Lexon's contract. So the contract, including issues of incorporation by reference, must be construed against Lexon. They couldn't possibly have overcome that. They couldn't have made that showing, and so judgment as a matter of law should have been granted for my clients. Beyond that, the parties never, Lexon continues to say the parties agreed to rates and times as listed in the schedule of rates, but that's not the case. No one has ever asked my clients to pay the rates that are listed in that schedule of rates. Mr. Semro for Lexon testified at trial and couldn't give a straight answer as to how he arrived at this 2% rate based on the schedule of rates. He admitted that he used criteria that weren't found in the schedule of rates. That was on the January 6th, the reporter's transcript at page 85 to 86.
Didn't your clients acknowledge they knew it was an annual premium, and then secondly, when they were billed, at least for the second year, they went ahead and paid the premiums?
As to the first question, no, my clients have never acknowledged that it was annual. Did I understand your question right? You asked if they...
No, it says specifically in the bond or in the contract that it's an annual premium.
Nowhere in the bonds or on the general agreements of an indemnity does it say it is annual.
It was charged on an annual basis under G subdivision bonds.
So what you're looking at is the schedule of rates. That document is what didn't exist in this case and in the files and in the contracting relationship until June of 2015. So my clients didn't know that document existed. Their broker didn't know the document existed, this one that says annual rates.
Why did they pay the bill?
So good question. So the lead negotiator or individual who was really managing this development it comes to a point where the project hasn't been completed in the first year, as was planned, and the Mahoney Group, the brokers, start demanding these additional premiums. And the additional premiums, in comparison to the interest that the developers are paying on the construction, the annual premium that they wanted was $39,000. They were paying $20,000 a month just in financing on the project. And the Mahoney Group, the brokers in this case, says to the developers, they say, we're going to shut down the project if you don't pay. And so as Mr. Crowley testified, they, quote, did the math and agreed to pay $39,000 to free their project from the allegation that it couldn't move forward without an additional annual premium. So they did pay that additional annual premium, but for that reason we argued that doesn't go to what my clients agreed to at the time of contracting. Subsequent, there is sorry.
So they believed they would get a bond for free?
They believed that they paid a single premium to secure a bond for its life. Because of the way bonds work, that it's this three-party situation, Lexon cannot cancel the bond. Lexon takes on the risk of the bond on day one, and they have no ability to ever get out of that risk. So my clients thought, we pay you to take the risk, you've taken the risk, we go and do our thing, you go and continue to be a surety. Lexon's position is, no, you have to keep paying us every year. But it's not like it's not like your home insurance where you have to pay an annual premium or else they can cut off the insurance. Lexon can't end this bond. So I think it's quite reasonable for a party, who doesn't have much experience in subdivision bonds to say, okay, I pay you to to issue the bond, and you've issued the bond, and you can't cancel the bond, so we're all square.
Are you saying that this was your client's first experience with subdivision bonds?
No, as my client testified, he'd been involved, or a representative of my clients, he'd been involved in 12 subdivision bonds, and his testimony was that he had never paid additional premiums. Now, there was evidence that some of those subdivision bonds, he should have been billed additional premiums, but he wasn't. I don't know why that is, but the fact is that the testimony in the record is that he had been in 12 subdivision bonds and he had never paid a second or subsequent premium, and so he was not aware and was not in the practice such that he could be held to be aware. I want to move to, with the court's permission, to another portion of our judgment as a matter of law argument. Again, the original position was this has to have been incorporated by reference. Now LEXON's position is, well, maybe if it wasn't incorporated by reference, it's parole evidence. And we addressed that in our reply brief, but I want to come back to it because there's an additional argument that perhaps should have been in the reply brief, and that's that LEXON at trial succeeded in admitting the schedule of rates in part based on the representation that it wasn't parole evidence. On the first day, the motions immediately pre-trial, there was an argument about what parole evidence could come in and out, and LEXON's attorney told the judge, and that document, speaking of the schedule of rates, is not parole evidence. That document is part of the contract, as evidenced by the language in the general agreements of indemnity. So the judge says, okay, we'll take that out of parole evidence and you can go ahead and admit it. So we'd argue they're actually judicially estopped now, in addition to the fact that this doesn't qualify as parole evidence. They're judicially estopped from arguing that it is because it's the same parties, it's the same issue, and they were successful before when they told the trial judge it was not parole evidence.
Is this the first time you're making this argument? The estoppel argument?
Yes, Your Honor. It should have been in it perhaps should have been in our reply brief, but LEXON had never before argued that this was parole evidence. They had said it's part of the contract, and if it's part of the contract, it's of course not parole evidence, it's part of the contract. And so when they raised that issue for the first time in their response brief, we argued, well, it's not parole evidence because it contradicts the contract, and I'm adding today that we believe they're judicially estopped from actually making that argument as well, given how they got it admitted at trial.
It's kind of hard to get a thoughtful response on an issue if this is the first time you're making it.
If we should have raised it in the reply brief, that's our error.
Thank you.
With the court's permission, I'll move to the late disclosure. So this case shouldn't have gone to trial. Both parties agreed that. Both parties agreed this was a matter of contract interpretation that the judge should have decided, but it did go to trial. And once it went to trial, there's two fundamental errors in admitting evidence that my clients bring today. And the first is that admission of the schedule of rates itself. Whether you analyze this admission under Rule 37C, which we did plead the wrong version of, or under Rule 16F, which we would argue our motion should be construed as, the judge must find a showing of good cause to allow that schedule of rates to come in. And good cause is analyzed in detail in the Marquez case that's laid out in the briefing. And we argue that there's simply no way to establish good cause here. Where I started with prejudice, you can't drag a party through 2 years of litigation, or you shouldn't be permitted to drag a party through 2 years of litigation preparing to meet a case that on the eve of losing summary judgment you change. That allows parties, the big parties that my Arizona clients contract with, to remove certainty from not just contracting but confidence in litigation if they can change the position that drastically. This was not simply a one witness that we wanted to add. This is what they then later argued was the key document.
Everybody knew about this sometime before trial, right?
Yes. In June 2015, my clients submitted a renewed motion for summary judgment. LEXON had no answer and explained that this motion for summary judgment, quote, forced its hand 2 years into litigation and forced it to collect evidence. Those were their representations, and those are quoted in the briefs, and say that they now found this. So there was a dispositive motion pending. We were past all dispositive motion and disclosure deadlines. The trial date had not yet been set, but that is because of the practices of the Coconino County Superior Court and Judge Hatch. Just like in the Marquez case, Judge Hatch does not set trial dates before she is completely confident that all dispositive motions have been resolved and a trial will proceed. So there was no trial date set at that point, and the delay that you see between the schedule of rates being disclosed and the trial date is because she is dealing with all of the motions to strike and motions in limine related to the schedule of rates.
But in terms of the culture, though, you knew about it and had time to prepare to meet that at trial.
Your Honor, every witness that was deposed either testified the schedule of rates did not exist or was not asked. In the case of LEXON taking depositions, was not even asked about the schedule of rates. So,
but you were able to make that argument, though.
yes. So my clients went to trial on the theory. Sorry, I misunderstood the question. On the theory that they could impeach the witnesses who had sworn this document didn't exist, and now all of a sudden showed up with it in their hand at trial.
So,
What position, legal position, had Lexon taken with regard to the schedule of rates before they were able to actually produce it?
Their in-house counsel, Mr. Belinsky, swore it did not exist.
Right, but what was their legal position about the contract and your notion that you couldn't be bound to a contract that was missing a key term, essentially? I mean, to the extent they'd taken any positions on.
I would argue that that was that last, the motion for summary judgment that my client submitted in June 2015 said, we've won. It's a written contract. You said you disclosed all the written pieces of the contract, and there's no annual term anywhere. And instead of responding, they discovered the schedule of rates. Your Honors, if I may, I'd like to reserve the rest of my time for rebuttal.
yes, thank you.
Thank you.
Counsel?
Thank you. May it please the court. This is a simple breach of contract case. And
Counsel, would you identify yourself?
oh, I'm sorry. Matt Sloan, I'm counsel for LEXON Insurance Company.
Thank you.
This is a simple breach of contract case. The contracts at issue in this case are two general agreements of indemnity. General agreements of indemnity required by a surety. Now, a surety requires a general agreement of indemnity in connection with issuing bonds. That's what a surety does. It provides bonds. Subdivision performance bonds, which are at issue in this case, payment bonds, performance bonds, license bonds, bail bonds, all kinds of bonds. And those bonds have different rates. Those bonds have different terms, depending on sometimes what the surety decides, sometimes what state or federal law dictates. So in this case, when the developer defendants went to their agent, the Mahoney Group, and said, we need subdivision performance bonds, one for this project with the city of Flagstaff and one with a project with the county of Mojave. They needed those because the local ordinances or regulations in those two jurisdictions required some form of assurance, and a performance bond, subdivision performance bond, was one of the types of assurances that they would accept. So the Mahoney Group went out on behalf of the developer and indemnitor defendants and sought a surety bond for them for the purpose of assuring to Mojave County in one instance and the city of Flagstaff in another instance that all of the subdivision improvements, the streets, the sidewalks, the utilities, would be installed. And the reason that's important to the municipalities is because they don't want developers getting a piece of property, selling lots to citizens, and then having those citizens end up with a lot in a subdivision which they have no water or no electricity. So that's why the developers in this case needed to get some form of assurance, went to their agents and sought out a subdivision performance bond. As Judge Winthrop, you had mentioned, the defendants in this case had previously gotten subdivision performance bonds on other projects from other sureties. And in fact, the performance bonds that were issued by LEXON in this case gave them a better rate than they got from any of the other sureties with whom they had dealt previously. So the purpose of the general agreement of indemnity is to set forth the obligations, both of the principal, which is usually the developer, and any subsequent and additional indemnitors, what their obligations are to the surety. The surety is agreeing, in this case, to issue a bond where it's going to subject itself to, in the case of Valley Springs Estates, $2.5 million worth of exposure, and in the case of the Cedar Ridge project, $971,000 of exposure. They're willing to do that, but only under circumstances where they have sufficient collateral, if you will, in the form of the indemnity agreements from multiple indemnitors who can and will promise that they will pay the premiums as they come due, and they will be responsible for reimbursing the surety for any losses or other expenses it incurs as a result of having issued the bonds. So in this case, LEXON agreed to issue surety bonds, subdivision performance bonds, to the developer defendants so long as they signed a general agreement of indemnity and had additional indemnitors, usually the principals or related entities to the principal developer, agreeing to pay the premiums that would become due, as well as be responsible for any additional obligations that LEXON may incur in connection with the bonds. Now, sureties issue lots of bonds, and in most cases, they issue more than one bond over the course of a relationship with a particular contractor, developer, or municipality. And it would be cumbersome both for the developers and for the surety to have a new general agreement of indemnity at each point in time when a new bond is issued. That's why these are general agreements of indemnity. They're not specific agreements of indemnity. They're not limited agreements of indemnity. And that's why they don't have specific rates or terms listed in the agreement. What the indemnitors and the principal are agreeing when they execute the general agreement of indemnity is this developer needs a bond. We're agreeing to be responsible for the premiums on this bond and any other losses and any other bonds that you may ever issue requested by this principal or any of the other indemnitors. So in this particular case, it was only one bond to Valley Springs Estates, one bond to Cedar Ridge. But it's conceivable, and it happens in many other situations, where the original developer, in this case Valley Springs and Cedar Ridge, could come back to the surety and say, you know what, now we need a different bond. Now we need a stop notice bond. Now we need a performance bond, and ask for an additional bond. At that time, there's no conversation. No one goes back and calls in all the indemnitors and says, hey, here's what the cost of these new bonds are going to be. Does everyone agree? Let's all sign off on it. It's not how it works. There's a general agreement of indemnity where they've already said, any bonds that LEXON issues to any of us who have signed this agreement, we're agreeing to be responsible to pay the rates and the premiums charged by LEXON. That's what the agreement says. Bonds, even though they relate to construction, they're really just financial instruments. And so the relationship isn't really that different from the relationship that a developer would have to a lender. So for example, if the developer had gone to a lender and said, I need to borrow $1 million for purposes of acquiring this piece of property that I want to develop, the lender would say, okay, I want a promissory note. I want a deed of trust. Usually when the developer is a limited purpose entity, the lender's also going to say, I also want the principals to sign guarantees. And so they do. They sign unconditional commercial guarantees. Those guarantees, they don't say what the amount is of the loan. They don't say what the rate is for the loan. What they say is that the guarantors are going to agree to be bound and obligated to pay any indebtedness, is usually how it's defined in a guarantee, of the principal borrower. Now, they may know, the guarantors at the time that the original loan is taken out, what that amount will be, because maybe they're involved in the loan process, maybe they're not. But that lender could lend additional monies to that same principal without any knowledge of the guarantors, and those guarantors would subsequently be obligated to pay those as well. There's another circumstance that I think is relevant to the particular issues here with regard to the general agreement of indemnity, because I don't think, our position has never changed. LEXON's position from the beginning of the case has never changed. We believe that the court should have granted summary judgment on our first motion for summary judgment solely on the terms of the general agreement of indemnity without any reference to a schedule of rates document. Because we believe, and there's no dispute, they signed the general agreement of indemnity, everyone agrees. There's no dispute that the language says that they agree to pay LEXON premiums for bonds at the rates and times specified by LEXON. That's what the general indemnity agreement says.
Is that kind of agreement enforceable
Yes.
with no price term?
Sure. It's akin to a credit agreement that a contractor would go to, say, Home Depot and say, I need to buy construction supplies from you and I want to buy them on credit. So they sign a credit agreement that says, I'm going to ask you for construction supplies, you're going to give them to me, and I'm going to pay you for those supplies at whatever prices you charge for them. So the contractor then goes to Home Depot and says, I need 100 feet of 2x4, I need 100 feet of electrical cable, I need 100 feet of copper tubing. Home Depot delivers it. Then Home Depot sends a bill at the end of the month for all the material that was ordered. The contractor doesn't get to go, wait a minute, I didn't have any idea that this was $10 a foot for this stuff. I'm not going to pay $10 a foot. I never agreed to pay $10 a foot. You agreed to pay for whatever materials were delivered at whatever rates Home Depot charges for
And
those.
there's no unstated assumption in that kind of arrangement that there actually is some objective price out there?
No.
Even if you don't see the piece of paper?
No, and in fact, when you're talking about things like electrical wire and copper piping, those things, the price fluctuates dramatically, and so you don't necessarily know. I mean, you may be able to look out and see generally right now copper is going for a certain price, but in a month from now or 2 months from now when you order it, it's going to be whatever it's going to be. Now, you certainly have the opportunity to, when you contact Home
And would that be that because there's an implicit understanding that usually costs this much, but it goes up when market factors make it go up, but there's still some underlying assumption that there's some objective basis to the pricing mechanism, isn't there?
Yes, but I would argue that there is one with respect to surety bonds as well.
But
And we're not talking here about the price, by the way. We're talking, but the price is what everyone agreed on. We're really, the only issue in this case was, were the premiums annual or was it a one-time premium? And the reason we believe that the schedule rates didn't really matter, although it was ultimately a very good document and it helped support the argument we've been making all along, which is we charge annual premiums on subdivision bonds. You agreed to pay us for whatever bonds we issued at whatever rates we charged for those and at whatever times we charged them. That's what you agreed to. Everyone, including the developers' agents who work for them at the Mahoney Group, testified that, oh yes, we knew that these premiums were going to be due annually.
Well, how, if a developer is looking for a bond, how can it determine which bond company to go to? I mean, how can it evaluate which is the better bond company to go to it if it doesn't have some idea of the cost of that particular bond? I mean, so did they know going in what the cost of that bond is going to be?
Well, what they do is they contact their agent. In this case, they hired the Mahoney Group, and the Mahoney Group is their agent. And what they do is they go out when the developers come in and say, "Hey, agent, I need a bond.
Right.
Go find me a bond." Sometimes they'll just go find one and say, "Hey, I found you one. Here's what it is. Does that work for you?" Sometimes they'll find a couple options and say, "This one will give you a better rate. This one will give you a better term," depending on the need. So they hire an agent who goes out and finds them the best deal for them, which in this case, the Mahoney Group went out and found them LEXON at a rate better than the Mahoney Group had found them subdivision bonds with two different sureties in the past.
So the argument is that the developer knew, or at least their agent knew what the rate was and how the premium was to be paid.
Yes, our position has always been that they knew clearly from the beginning that this was a 2% premium, which is not in dispute, and that it would be due annually. And no surety, no right-minded lender would expose itself to, in this case, $3.4 million of risk for 2% of that amount for one time, when, as opposing counsel mentioned, the bond is going to be in effect until it's released and discharged by Mojave County or by the city of Flagstaff. Going into these arrangements, LEXON had the expectation that it was going to get one premium on each bond because the developers represented, we are going to, within a period of 1 year, complete these subdivision improvements. And we need a bond because that's what's required by the municipality. So our expectation was we charge them 2% for 1 year, they get the job done, the bonds are released, and we move forward. But when they don't get the job done in the first year, now we have a second year of exposure. They have to pay another premium. That's how it works. That's how it works with this surety. That's how it works with the other sureties that they did business with. If you look at all of the general agreements of indemnity that were admitted in this case, they all say relatively the same thing, which is that you, as indemnitors, agree that you're going to pay the surety for any bonds issued at the rates and times specified by the surety. That's what all of those agreements say. If I could turn a little bit to the specific arguments being made in this case. The first issue on the judgment as a matter of law.
Before you go to that, can I ask you about David Hickman's testimony?
Sure.
I think what you're asserting, the gist of his testimony was that he communicated the premium to John Crowley.
Well, his testimony, I don't believe he testified that he specifically remembered communicating that to Mr. Crowley. What both he and Ms. Fikes said is, listen, we know these are annual premiums. We've dealt with subdivision bonds for many years. The premiums have always, in our experience, been annual premiums. We always convey to our clients what the amount is and what the frequency of the premium is. We believe we would have done that in this case, but they didn't have a specific recollection of having done that. Does that answer your question, Your Honor?
Yeah, the way you put it in the brief, he testified that Lexon quoted him a premium rate of 2% of the penal sum per year on both bonds. He testified that he would have communicated that to John Crowley, but he admitted he did not recall the specifics of that conversation.
Right.
Now, do you aver that that evidence is sufficient for a fact finder to determine that John Crowley had been advised of the annual nature of the premium?
I don't know that it's sufficient, but I don't know that it's necessary either for Lexon to have prevailed for a variety of other reasons. Because I don't think it was necessary for him to know at the time that the premiums were annual.
Well, what's your version of the transaction where this second premium was paid?
Our version is that,
How did that come about?
as I mentioned before, the expectation was the project would be done within 1 year.
Right.
When it's getting close to the end of 1 year and it's clear that it's not going to be done, a second premium is charged. That's done by the Mahoney Group, who's acting under as Lexon's attorney in fact for the purpose of collecting premiums. They get a percentage of those premiums. They went to the developer and said, hey, you're not done within a year, another premium is due. And at the time, and the record is clear, that the indemnitors, not only did they pay the second premium without complaint, without issue, they didn't say, wait a minute, we thought it was a one-time premium, why are you sending us another bill? Not only did they not do that, they paid it, but they also worked pretty hard in multiple instances to try and get the penal sum of the bond reduced. In other words, they go to the surety and say, listen, you issued a bond for $2.5 million, $500,000 worth of stuff has been done. And so they go to Mojave County and say, listen, will you agree to reduce the amount of the bond? Because your risk is now not $2.5 million, it's $2 million.
Which would reduce their annual
Which would
premium.
reduce their premium.
So what legal consequence do you argue comes from the fact of that transaction?
That the parties' conduct prior to the time this dispute arose is clear evidence of what their intent was at the time they entered into the contract and during the course of their performance thereunder.
And evidence of knowledge that there could in fact be a second or more premiums charged.
Right, and if you look at the testimony during the trial, what Mr. John Crowley said was, well, the reason we did that is because there was this threat that Mojave County was going to, or shut down the project if we didn't pay the premiums. And we were worried the city of the Flagstaff would do the same thing. Other than John Crowley's testimony, it's not a shred of evidence that was offered at trial to support that contention. And in fact, if you think about it, it doesn't make any sense. Mojave County never has any interaction with Mahoney Group. They don't have any interaction with LEXON. Mojave County and the city of Flagstaff get a bond that says, we, LEXON, will take care of this. If the developer doesn't do it, we will perform. They don't care if premiums are paid. They're not going to stop the project because premiums aren't being paid. LEXON is obligated, whether premiums are ever paid, to complete the performance under the performance bond. That's what their obligation is. So the fact that premiums were being paid or not being paid is of no consequence to Mojave County. They wouldn't care. They have no reason to care, and they would never have a reason to tell a developer, we're going to shut you down because you're not paying your premiums. It doesn't make any sense. And in fact, in this case, on the Valley Springs Estates project, a bond claim was made against LEXON in federal court by a subsequent developer. That case is now up at the Ninth Circuit on appeal. So LEXON is, not only are we arguing for premiums because they're just due, because we have continuing ongoing risk, you can see we actually have incurred losses as a result of having issued that bond by virtue of that claim. I haven't had a chance to hit too much on the issues that actually were brought up. I only have 2 minutes left. I think the briefs pretty clearly make the legal arguments. Our position is that there was sufficient evidence at trial across the board, even without the schedule of rates, for the jury to make the decision that it made, which is that the general agreement of indemnity obligated these defendants to make premium payments annually or biannually, whatever the surety set those rates for these particular bonds. There was the evidence in terms of the testimony of the LEXON representatives, of their own agents from Mahoney Group. There's significant discussion about the lack of credibility of Mr. Crowley and the contradictions in his testimony. And the only other point that I want to hit on and relates to the comments that I made in closing, that there's been a suggestion or argument that I somehow engaged in misconduct by making the argument that I made. If you look at the closing statement, if you look at the testimony that I'm making, or the argument that I'm making, I'm specifically referring to the language in the general agreement of indemnity that obligates an indemnitor to make payments to the surety at the rates and times specified by the surety. Now, the appellants have argued that by saying that, I was arguing that premiums are always due annually. Well, that's factually not true, and it doesn't make any sense if you think about it, because as they've argued, and as we've acknowledged, the general agreements of indemnity, they don't say premiums are annual. None of them do. In fact, our agreement says, and where such charges are annual, they will pay the same. I wasn't referring to or suggesting that those agreements always require annual premiums, only that all of those agreements, and if you look at all of them that have been admitted in this case, all have that same language, requiring payments be paid when they're due and in the amounts that the surety sets them. And so for all the reasons in the brief and for the reasons I've explained today, regardless of whether or not the schedule of rates was admitted, which I think was properly admitted, it's not the parole evidence that we're talking about when we talk about parole evidence supporting the jury's finding. We're talking about all of the other things, the testimony of the witnesses, the other documentary evidence that was submitted that supports the testimony of all of those witnesses, clearly showing that these defendants knew and always intended for the premiums to be due annually. Their conduct supported that. Their arguments to the contrary now are just after the fact attempts to try to avoid the clear liability that they have under the terms of the bond. Our argument has always been consistent. The schedule of rates perhaps should have been discovered earlier, was not, and was submitted as soon as we were able. They had access to it for 7 months, could have discovered it, or conducted discovery on it, did not. That's their choice. They made a tactical decision. And so for all the reasons in the brief, I'd request that the court affirm the jury's unanimous verdict, the judgment entered by the court, as well as all the determinations by Judge Hatch with regard to the issues in this case, as well as award LEXON its attorney's fees and costs.
Counsel, before you actually produced this schedule, did LEXON people testify that the schedule didn't exist?
LEXON's collection attorney, Mr. Belinsky, did testify that he was not aware of any schedule of rates, written schedule of rates. If you look at his testimony, his deposition testimony, which I'm not sure if you have or not, he specifically testified that he wasn't aware that any such written document existed. He was mistaken. Thank you.
Thank you, counsel. Roberta?
Thank you. Let me start by, again, bringing this case back to the actual contracts at issue. Counsel just said that the general agreements of indemnity say that my clients agreed to pay at the rates and times specified by the company. That is not what they agreed. What they agreed was, the indemnitors will pay premiums and charges at the rates and at the times specified in respect to each such bond in the company's schedule of rates. That's, I'm sorry, I don't have the trial exhibit number, but it's LEXON Bates Stamp 1. As Judge Thompson was asking, is that too vague? The cases that LEXON's relied on to say that you can have these unspecified pricing terms and those can be upheld as a contract, those are cases in which that list was readily available. Banner Health, the list was actually published with the Arizona Department of Health. The Pacific Natural Gas, that kind of fluctuating price, those price lists are objectively available and the contracting parties can access them. Here, the testimony of Mr. Hickman was, Mr. Hickman, how do you find out what the premium is? I call LEXON and he just tells me a number. That was the testimony. And that's part of what Judge Thompson quoted was he was repeating, I called LEXON and they told me 2% per year, so that's what I understood.
But it strikes me that the legal requisites for a contract are somewhere in between the positions that you two are espousing. It seems to me that a contract that just says LEXON charges you whatever they say and you agree to pay whatever they say, that strikes me as an illusory contract. On the other hand, I could see a course of conduct in a business where you agree to pay according to what LEXON says is the schedule of rates, and you never question whether the schedule of rates exists, but there does have to be some sort of agreement that there's some objective reality to this schedule of rates, whether there's actually a piece of paper or not. So I'm not sure that the incorporation by reference doctrine requires that both contracting parties actually have access to the piece of paper, especially when they don't seem to care. But it does seem to me there clearly has to be some objective basis for that price term.
Your Honor, I agree and want to make clear that we don't say that the schedule of rates proves that we didn't owe annual premiums. What we say is, on the case that LEXON brought, given all their representations and their testimony under oath, to Your Honor's question, did they testify that there was no schedule of rates? Counsel, I'm sorry, but he quoted the testimony inaccurately. It's quoted in our briefs. The question was, does LEXON have a schedule of rates? The answer was no, full stop. That was the testimony of LEXON's only disclosed witness. So our position is not that this somehow proves that the rates were not annual, but the case that LEXON brought, they said, this is a written contract, it's all right here, and on their case, they couldn't make their case, and so my client was entitled to judgment as a matter of law, and instead the case got flipped on its head. And not only with the schedule of rates, but what I didn't get to before was this industry standard argument. And counsel just spent the first 6 minutes of his argument today bringing up an entirely new factual argument that is not to be found in the record. There is no evidence in the record about the whole general agreements of an indemnity can apply to multiple bonds, and so that's one of the reasons they have to be annual. That is not in the record, and I don't think that's anything this court could take judicial notice of. And that's what happened at trial, was instead of showing up and talking about, I'm sorry.
But why don't we talk just for a moment about your assertion that the disclosure of this document was a game changer. I'm sure you acknowledge that the decision by Judge Hatch to allow the case to proceed now with this piece of paper is a highly discretionary call that we have to give considerable deference to. You acknowledge that, do you not?
I do, Your Honor.
I mean, it's late disclosure, and I can see how it might have upset your expectations, but we entrust a lot of those kinds of decisions to trial courts and don't often, or without significant cause, we don't disrupt those.
If I can respond, I'm almost out of time.
I'll give you a chance, because, I mean, that seems to be kind of at the cusp of what you're arguing.
Your Honor, absolutely, this court can only
Take your time. I mean,
Thank you. This court can only overturn that decision to admit the schedule of rates if it finds an abuse of discretion. But the law is clear that an error of law is an abuse of discretion. And Judge Hatch here documented her reasons for admitting the schedule of rates, even though it was late disclosed, and in direct contravention of Marquez and Allstate, which say that you must consider 5 factors: the reason for the failure to disclose, willfulness, the prejudice to either side, efforts to resolve short of exclusion, and the diligence in litigating to date. It says you must consider all of those, and her order says it doesn't appear that it was willfully withheld, so therefore I'll let it in.
and that's maybe one factor.
And that is one factor, but it's not all 5. And we think that the law is clear in Marquez that it is all 5. And so that was an error of law. And this court can go back, look at all 5 factors, and side for us that on the whole, even if it wasn't willful, the other factors require that the schedule of rates be stricken and not admitted. And if it makes that finding, unless this court is confident that it didn't affect the verdict, then reversal is required. Thank you.
Thank you, counsel. We appreciate your arguments today. We'll take the matter under advisement and issue a decision in the court. We stand adjourned.